Today's podcast is important for each person who owns land in Canada. It's a court decision that is reshaping the conversation about land ownership in this country. Welcome to Chai and Chat with Mohini. I'm Mohini Singh. The city of Richmond is a family-friendly place with quiet cul-de-sacs, joggers tracing the river's edge. Richmond feels polished, modern, predictable, and safe. But beneath that calm exterior, something seismic has been bubbling for more than a century. A forgotten village, a buried oral history, and a legal fight that has just cracked open the foundation of land ownership in Canada. When the Cowichan Tribes stepped into court, they weren't just challenging a boundary line, they were challenging the story this country tells about who owns what and why. And when that long court ruling landed, it sent all levels of government scrambling. Homeowners are now worried, banks are reconsidering their lending policies, and Indigenous nations feel vindicated and heard. Because this wasn't just a case, it was a reckoning. This is the Couchin decision. It's a decision Canadians today simply cannot ignore. To help us understand the implications and unpack the meaning of this case, we have Jeff Robinson, a top litigation lawyer who's with Rush Ihas Hardwick in Kelowna. Welcome, Jeff. So my first question to you, please have some chai.
The chai is excellent. I've tried the chai beforehand and it's excellent.
Thank you. What is this case about? And what is this hidden village? And what is the background?
All right, so let's start from the beginning. So the beginning was there were Indigenous groups in British Columbia long before the British and Europeans showed up. And some of those groups have descendants who are here today. In this case, it's about a group of descendants who've banded together under the name Cowichan Tribes. There's actually a few distinct Indigenous groups from the traditional Cowichan territories that have recognized themselves as the Cowichan Tribes and brought this case. And that group of people, their ancestors, had a village on the south arm of the Fraser, where Richmond is now.
Which we call Lulu Island.
Correct. And also the areas around that village were used by them for gathering resources and supporting their way of life. And so when the British came, they were in possession of those lands. They occupied them and used them for their traditional way of life. But over time, they were blocked from using those lands when the province came in, divided up the lands into little parcels, and then had those parcels given to different owners. And so the legal system of BC effectively created ownership interests which were inconsistent with the Cowichan people from continuing to exercise their rights over the land or their practice over the land they'd had for many, many decades, if not centuries. And so the Cowichan went to court and they sought something called Aboriginal title. And Aboriginal title has been in Canadian law since the late 90s. And it's this notion that ancestral rights can exist. People who had use and occupation of land prior to the assertion of European sovereignty can have rights in that land. And in this case, the Cowichan wanted a declaration. That's the court basically saying to the world, yes, these people have Aboriginal title over these lands.
So all it was clarity on the term Aboriginal land.
Somewhat, it's a bit of both. So one part is saying, do they or don't they have this thing we call Aboriginal title? But the really important part of the case, and the reason it's making waves, is that the Cowichan also sought rulings to clarify what happens when you have Aboriginal title on the same piece of land over what we call fee simple title.
That's my home, my personal property.
That's exactly it. Fee simple title is the dominant form of private land ownership in Canada. And in BC, fee simple ownership is important because it's protected under our land title system. You register your fee simple title with the land title registry. And there are protections in BC law for owners of fee simple titles that are registered.
So that's a really good point you raised, Jeff, because that brings me to my next question. What does this decision, what legal bearing does this have on my home? That's what people are worried about.
Okay, so let's step through it in four quick parts, right? So first, Cowichan did have Aboriginal title. They were declared to have Aboriginal title over about 800 acres of land. Secondly, and this is important, the court found that Aboriginal title is senior to fee simple title. In other words, it has primacy, it comes before, it is outside the land title system. And that's important Because the third point is, it means that the protections in our land title system that essentially guarantee your ownership if you're the registered owner don't apply to Aboriginal title. In other words, Aboriginal title will render or can render fee simple title defective and invalid. And that's what happened to the titles held by Canada and Richmond. And the fourth part is what addresses your home. The court found, and this was the first time it's been found, that fee simple title and Aboriginal title can coexist, but only until such time as the holder of Aboriginal title seeks to enforce their title against a fee simple owner.
So that leaves me on dangerous ground. It really does. Yes, they can coexist, but that's as long as the Aboriginal title holder doesn't call in their ownership of my land. So what protection do I have as a homeowner?
So as far as I know, you don't have a home on Lulu Island or in the...
No, I'm just talking generically
those
speaking.
Those people. So yes, in theory, yes, you'd think that this is a very serious risk to someone. But I think a lot of the fear-mongering overlooks the broader context for this case and why the courts are making these rulings. And so as a first step, this is a trial-level decision in British Columbia. Already, December 11th, the New Brunswick Court of Appeal came out with a decision which says you can't have Aboriginal title coexisting with fee simple. It can't happen. So already
It can happen.
It cannot happen.
Cannot.
New Brunswick says cannot, BC says it can. So already we don't know if the BC law is going to stand up. It's going to be appealed to the BC Court of Appeal, appeals Supreme Court of Canada. But the bigger context is this. The court has been trying for the last couple of decades, 3 or 4 decades, to force the government to deal with this issue, to force government to recognize that, look, these lands were never properly surrendered. You need to do something. And so we've had this progression of recognizing there is a thing called Aboriginal title. And we've had decisions that tell us, well, if there's Aboriginal title over wilderness crown lands, untitled lands, we have a duty to consult. And now for the first time, we have a decision in BC that says, well, look, if there's Aboriginal title on lands that are now fee simple title, that's a problem for fee simple title. But the whole impetus here is to force government to wake up and do something about this. Because the courts, my sense is they don't want to take people's land away. They don't want to be put in that spot. It's just trying to create enough pressure to make this go away.
So the provincial government is challenging this decision, this court decision, because it's created a huge uproar in Richmond, as we've heard in the news. A hotel owner got his financing withdrawn, and this creates a sense of uncertainty. Investment will not come to our province, and that'll have a ripple effect economically. So what now?
Well, what now is we're going to have more Court of Appeal, perhaps Supreme Court of Canada, to clarify this decision. But we should hopefully also have governments and the population as well supporting negotiations. There have been successful Aboriginal title negotiations. The Tl'uqtinus First Nation has got a final agreement. The Nisga'a First Nation has a final agreement. These are not problems that can't be overcome with good faith negotiation. And I think part of it is that the public has to perhaps lean into this a little more and understand what's actually going on and see the justice in having these negotiations.
So, end of the day, why is it important for us? You say the public has to lean in. Why is it important we keep our ear to the ground and see what's happening? Why is all that important?
Well, because right now there are immediate consequences. There is great uncertainty for land ownership as a result of this decision, because we know there are Aboriginal title claims covering essentially the entire province. And so I think the province, is going to have a real cost as long as that uncertainty persists. And we can try to eliminate the uncertainty through long court fights. We can also eliminate the uncertainty through negotiation. And so a way of thinking about these cases, it's not so much win and loss. It's going to be an evolution of the leverage in these negotiations between government and between the Indigenous groups seeking Aboriginal title.
So this is all at a very high level. For us, people on an everyday level who are just trying to make a living, feed their families and get on with it and pay their mortgages and get on with it. What happens if, say, a neighboring Indigenous band, claims the area where I have my home was their former hunting and fishing area? Where does that leave me? I'm just saying me as an example.
If we assume that there was actually a legal claim filed against you personally.
No, I'm just saying my community.
Well, if there is a claim like that, you should find out more about it. And you should engage with these people, because the word that the courts use and that the government is using and the Indigenous groups use it too is reconciliation. We have to reconcile the interests of the, I guess I would use the word colonial system of laws and the Aboriginal title interest, which came beforehand. We have to bring them together in a way that's harmonious. And you're going to promote that by understanding what they see in your land, what they want from your land. I don't think you need to worry about losing your home. I would be surprised if the government didn't step in and appoint lawyers to defend private landowners.
So at the end of the day, your legal opinion, which you're not supposed to give, as you said, but from a legal point of view, homeowners really don't have to worry about losing their private properties. This would really take into account Crown land and, municipal land.
I mean, every lawyer who's been doing it long enough gets surprised in court. So I wouldn't say it's impossible that no one will ever lose their land. At the same time, we have to realize this is part of a broader political process. The legal process is being used to create leverage and basically force government to live up to its obligations or determine what its obligations are. Just pay attention to it and correct historical injustice. And it seems to me that courts taking away land from individuals is not going to promote reconciliation. It's going to fearmonger. It's going to drive the parties apart. Already you see political leaders calling for we should end all negotiations. Well, that's the exact wrong reason. That's going to force the courts to have to do more. The courts want this to be resolved on a political level. They don't want to be the ones having to bring down a hammer. It's not for them to do. It's essentially a political and moral question for Canada.
Jeff, there's another point I want to raise is that we now, whenever there are public meetings or public gatherings or you're speaking at an event, you always open with the land acknowledgement. How much of a legal bearing does the land acknowledgement have? Or is it simply rote that we are saying it because we're supposed to?
I mean, lawyers are clever people, and the Indigenous groups have great lawyers. And so it wouldn't be surprising if there were arguments made based on those land acknowledgements. And there's two ways that come to my mind that they could have an impact. One could be an admission that this land is unceded. And unceded is an important word because it was used in the Royal Proclamation when King George basically opened up Canada to Britain. And unceded means it's still theirs. And so it could be taken as an admission that, well, you said your land's unceded, therefore it is unceded. That seems to be somewhat unlikely because there's going to be lots of proof, and who knows, when you say unceded, would even know what it means, right? Like It's a flexible meaning, perhaps. The other way it could be important is that it could eliminate a defense that most of us would have. And so under the Land Title Act and under the law generally, the person known as a bona fide purchaser for value is protected. So a person who comes in good faith to buy land and doesn't know about a prior claim and pays honest, good money for that land, the law is always going to protect that person, the bona fide purchaser for value. But if the purchaser knows about another claim to the land and ignores that claim and pays for the land, now they're no longer a bona fide purchaser. And so when people acknowledge this is unceded land, whether they acknowledge it's actually unceded, they're at a minimum acknowledging a claim that it could be unceded. And so that might affect the availability of the bona fide purchaser for value defense.
Wow.
So that doesn't mean that we have to be hostile to these
Yeah, should we not be saying it? Or
I mean, that's a personal decision for people. I mean, I've been saying it, and that's because I'm comfortable and confident that our political leaders, the Indigenous groups, will be reasonable and we will reconcile. And the fact is that for many people, their lands will be unceded traditional territories. And so the fact is, you're not comfortable saying it, you don't have to say it, but it's more productive instead of getting angry about it, just explain, look, I'm not doing this screening this way because I don't know if my land's unceded territory or not. Like, I just don't know. We may have heard things, but unless you've talked to someone who has the oral traditions and can convince you that this was the site of a village or was traditionally used, you don't have to take it at face value.
The other thing is, how does all this impact the whole move towards truth and reconciliation? We've come a long way just in the last few years.
Well, that's the open question right now. I mean, the court, my sense is that they are trying to promote reconciliation. And we see a division between BC and New Brunswick. New Brunswick actually said in their decision, look, finding Aboriginal title on privately owned fee simple lands, as opposed to ones that are owned by government, finding Aboriginal title and declaring Aboriginal title in respect of privately owned fee simple lands is counterproductive. It doesn't work for reconciliation. It's going to fearmonger and scare people. And so we think, us, the New Brunswick Court of Appeal, that those declarations cannot be made. BC took a view, yes, we can declare Aboriginal title where fee simple lands, and they can coexist. And the BC Court perhaps has a more sanguine view of the population about how we're going to react to these kinds of findings. People can recognize that there are adults in the room here, and this is not a challenge that can't be overcome. We have precedents. We have the Tl'uqtinus and the Niska agreements. They take a long time, a lot of hardworking people, but those are the best way to resolve this. Final agreements that respect all parties and consider all viewpoints.
End of the day, we have a long way to go before we have a final solution on this, if not a generation to go.
I would hope it's within a generation, certainly.
Yeah. Thank you for coming. Thank you for clarifying this. Thank you for unpacking this incredibly complex situation. And thank you all for watching Chai and Chat with Mohini. From all of us here, goodbye.